Hello, Adam.
Fancy running into you here.
Hello, everybody, and welcome to today's webinar brought to you by Sarah Dawson. Today's presentation is entitled Embracing COVID Normal for Employers. Who would think the last time we had a presentation like this was in November 2019, how the world has changed since then, but employment law matters are still relevant and topical. It's our pleasure today to have with us Adam Foster from Macpherson Kelly. Adam is a senior associate specialising in employment, safety and migration at Macpherson Kelly. He works out of the Melbourne office. Macpherson Kelly is a national firm of lawyers. Adam is going to be talking about relevant employment law issues. There will be an opportunity for you to ask questions at the end of the presentation rather than throughout it. You might actually find that your question is answered by Adam as part of his presentation. So if you could hold your questions until the end, Adam will then do his best to answer them. Any unanswered questions can be dealt with afterwards. There'll also be a survey for you to complete at the end of today's presentation. We would appreciate your feedback in relation to that. And a recording of today's presentation will also be sent to all attendees. Adam, over to you. We're looking forward to your presentation.
Thank you very much, Murray, and thank you everyone who's attended. I can see there's a hand up, and I might just get the person who's put their hands up. I'm assuming that's something to do with the chat, so I won't say anything more about that. But it'd be grateful. There's 8 hands up that I can see now. I'm not sure what those hands are up for, but if you could take your hands down, that'd be great. It's good to know that you're here and present, and I'll say hello. As Murray said, we're going to be really talking about some key employment issues for the next, hopefully 40 minutes or so. Hopefully that will be interactive, and I look forward to your questions at the end. Please don't hesitate to write them in the Q&A box when they turn up. I just want to give you an idea of where we're going. There's a whole list of items up there on the slide that we're going to cover off. But really, to be fair, if we want to kind of frame it in some way that's useful and helpful, I just encourage you to maybe think of it as we're looking back, but we're also looking forward. We're looking back over the last year, not because we want to revisit COVID and lockdown 1, 2, or however many 0.0s it was, but it's simply because there was a lot of significant law developments last year that will really inform where we go, what the employment landscape looks like moving forward. And there's also one matter that I haven't touched on that we won't cover today, and that's around contractors, because that is a hugely evolving space in and of itself. The first two I really want to talk about really briefly is the portable long service leave and labour hire licensing arrangements. And I'm really touching on those because they've been around for a good little while now. They came into effect, pretty much in the last 18 months or so. And what's really important for us to remember about, say, the portable long service leave scheme is that there are employers and workers that will be deemed to be eligible, whether it's security, cleaning or community services. And whereas you might previously have invested all those funds for the long service leave scheme within your business, you now have to pay that to an authority within 14 days. There are some rates there, percentages of what percentage of the payments you have to make based on wages, ordinary wages. But the important thing is for you to think about the reason why this has been implemented is a part of a wider scheme to stamp out wage theft or failure to pay employees the correct minimum entitlements. And I think it's good for you to also have that in the back of your mind, because if we're looking back, if we're looking forward, that is really the prevailing theme that is affecting change in the employment law sphere both in the last 6 months, but also moving forward. That is the desire to stamp out underpayment or non-payment of wages in whatever form that takes. And part of that is here with the portable long service leave scheme is ensuring that people who are in maybe vulnerable or highly I was going to use the word transmissible, but in the current climate, that's probably not a good word to use, but highly flexible and varied work, such as people in the community services sector where they might move from employer to employer to employer to employer. This is meant to still ensure that they might have access to otherwise long service leave benefit that they might not get because they've been in the sector for say 7 to 10 years, but had 4 employers over that time. So never quite got to the point that where they aim to be in a position to take long service leave. For most employers, and up until October last year involved in the community services sector, you had to deal with this really awkward test of the predominant activity of the substantive role being community services work. It's typical lawyer speak for something, the vibe, the marbo of it. Does it kind of look like something? Then it will be something else. Thankfully, that was dealt with in changes from 1 October that really bedded down and honed in on exactly where community services work fits in, but also those employees who are eligible or not. Fundamentally, what it's meant now is that eligible employees must be, not just the employer must be in the community services sector, undertake community services work, but they also must be covered by a relevant award. Community services work now includes all home care and private residences, regardless of the age of the client, previously excluded. It now covers NDIS service providers, previously excluded, and also covers services that support, supervise and manage the provision of community services. That's an important distinction because, as you'll see, there are some modern awards where that will be actually quite relevant. The employers are there. It now includes community health services but excludes for-profit children's services. So whereas you might ordinarily think, well, some childcare, some for-profit services would apply, they are excluded. The test's been replaced. So now it's this case of, well, what award are you covered by? Are you covered by the SHADS Award, the Education Services Award, Supported Employment Services Award? Fundamentally, I think what it means for us is we're here online, we're actually asking questions. And the questions we should be asking are, would I be covered by the scheme? But more fundamentally than that, are my employees covered by the scheme? Are they covered by the SHADS Award? Do I have the right classifications? And certainly from our clients, then what we're hearing from them, actually getting award classifications has always been important, but it's going to be more and more important, particularly as state governments try and tie their state-based regulation to federal structures like awards. So really knowing which award it applies to, and particularly when you think about SHADS, and that does have some management levels that it covers, like making sure you know who's in, who's out, who's covered, who's not, is essential because you don't want to be stuck in this position where you should have had someone say registered for this scheme and they didn't. At the same time, you also need to be able to answer that question for the person who was maybe previously in the scheme's first 18 months of existence covered by the scheme. They may not now be covered. And that's actually an important distinction because it means you might not need to be paying money into the scheme anymore. There are some questions you really need to be thinking about, and happy to have a conversation with you about what that could or should look like. But fundamentally, know what awards your staff are covered by, and then make sure you've got the right classifications within them. Now, I'm only touching on labour hire licensing because it has been around since April 2019. It kind of slipped through under the radar because for most people it seems fairly obvious. Like the portability scheme, it deems the cleaning sector and the security sector to be requiring labour hire licences. So you just need to be aware that there are some schemes that are just a part of this regulatory regime because of the sector that they're in. It also covers meat and poultry processing. I'm raising it now for a couple of reasons. One, there's been a muted national scheme that I think has kind of died I wouldn't say it got infected by COVID-19, but it's certainly been put on the back burner while the government deals with COVID-19. It's also important to appreciate that different states have different schemes, and you'll need to have separate applications for different states. There's no sort of national recognition or mutual recognition between jurisdictions in that regard. The legislation briefly provides for people to require to hold a license, goes without saying, a register for you to check, and I'll come back to why that's important in a moment. A requirement that if you use, say, a contract cleaner in a commercial setting, so think about your office spaces, or if you use security guards, thinking about an event you might host that needs security, you're going to need to be making sure that you only use a licensed provider. And then, of course, there's always an authority to be checking and rechecking that people are doing the right thing. And again, the funding of that authority comes from the people applying for the licenses. Thinking about what I was talking about before about ensuring that people are paid their minimum employment entitlements, this scheme is also used to reinforce that because it requires companies to disclose or businesses to disclose that they're compliant with their fair work requirements, tax requirements, workers' comp, health and safety requirements, things that are a lot of them are normally regulated by the Commonwealth government. The state governments are sort of seizing on them as a means of trying to ensure that they can stamp out any underpayment or non-payment of workers' wages. There are some people who are excluded from the scheme, and this is really important if you have a corporate group of entities. It's really important that you identify that, or if you're dealing with students or people on vocational placements, it's not unsurprising. But like every good lawyer talks about where things go wrong, I just want to talk about the risks now. And the reason why I want to talk about the risks are around labour hire licensing. When I think about it, it's actually more for people who are hosts, who use organisations that should have a licence or businesses that should have a licence. You can be fined as an organisation that hosts if you haven't actually done your due diligence and asked the question, do you have a labour hire licence? So an easy thing that you can do to ensure that the cleaners that you're using, that the security guards that you're using have a labour hire licence is that you just ask the question. You ask them to produce a copy of that. You ask them to produce, you could go onto the register and have a look for yourself. But that's a really important case that you want to be dealing with, because you don't want to be like the recent case in Queensland where an entity who didn't have a license was fined, as I recall, $60,000 for not having the license, sorry, $90,000, but then also the host was fined because they were found to be in doing business with an unlicensed labour hire organisation. So there's real risks for your organisation, and so there's real reasons to be asking pretty straightforward questions, preferably in writing, preferably in an email, so you can keep it on record in case the regulator comes sniffing around, because they have moved from a process of getting people on board to now a process of regulating and going out to the obvious targets. And they are principally more concerned, I think, about agriculture, but they're still obviously concerned about security sectors and cleaning sectors as well. Make sure you've got things in writing. Make sure that you keep a copy of any requests for a labour hire licence so you can rely on that. And then make sure your contractual documentation provides you with appropriate protection if you find that someone is not a licensee and they don't hold a licence. Really, really important. Of course, it might be that you yourself find that you're hiring out people to go work in another organisation. You want to be asking questions about whether you need a license or not, because it might be that you can tweak your structures so you avoid the need for a license and avoid the need to be spending a significant amount of money on an annual basis going to the current government authority. Now, before I keep going, we're going to look at casual employees in a minute. There's one thing to be said. The labour hire licensing, as I said, does not have mutual recognition, but that's very distinct from the portability long service leave scheme, which does. And that's significant because ACT currently covers the community services sector, and from 1 July this year, Queensland will also cover that same sector. So it's really important to remember that mutual recognition may mean that someone people can transfer an entitlement, but also that they might need to be recognised here and still actually remain on the books, even though they're up in Queensland. If head office is in Victoria, for example, that they may need to, you may still need to keep paying into the scheme, not just because they've gone north of the Murray, so to speak. Now, I want to talk about casual employees. I think when this hit the airwaves in about August last year, people kind of went into shock. The Australian Financial Review was talking about the cost to businesses being in the billions and billions and billions of dollars. I think 16 or between 16 and $30 billion. It's quite simple why that was the case. This decision in Rosado, I think, caused a few headaches because it seemed to undo some of the Commonwealth Government's work to stop casual employees double dipping. But also it really did seem to set a firm test around when someone was not a casual and when someone was. To be honest, what it really did was kind of bolt down what we've always understood casuals to be, but not how often in business we engage people of casuals, and that is someone who has irregular and unpredictable work. They don't have a reasonable expectation of ongoing work. So the work isn't systematic and it's not regular. That's really what the court was taking an aim at and saying, well, that is the true definition of a casual, unlike Mr. Rosado here. And Mr. Rosado was someone, as you can see, who had worked with WorkPac for many, 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 many years. He was employed on 6 consecutive contracts of employment. He was allocated a roster up to 7 months in advance, which to some extent makes sense. He worked in a mine. Mines operate to a certain specific timetables, and they want to know what their staff shifts will be up in advance. Unfortunately for WorkPac, though, their documentation let them down. Their processes let them down. And I think, to be fair, the reality is that Mr. Rosado was always going to be considered a permanent employee. Probably what's the unfair part of this is the ultimate outcome. But the documents let Mr. Rosado down because they didn't really talk much about the casual loading that he received. They didn't really talk about the fact that that casual loading was to offset any other leave entitlements that he might otherwise be entitled to. And the casual loading was not the same across the 6-year period. In fact, the court in its analysis was able to see that, at the start it was 25%, but it dropped to as low as between 8 and 10% at one point before kind of nudging back up to 15%. So even if you could say that, and this comes to the set-off question at the end, but even if you could say that he was a casual with a loading, the loading itself was insufficient over time. So you have a contractual relationship where the person is said to be casual. You're giving them a shift roster 7 months in advance, so their work is predictable and systematic for that period. And then you're paying them in a way that doesn't really suggest it could fully compensate for them not receiving the entitlements they would normally be entitled to. So when Mr. Rosado finished, he was considered to be a permanent employee. And that decision was found at each instance of the court, and the Federal Circuit Court, full federal court, and full federal court. And of course, now it's on appeal. I suspect that appeal might be rendered moot by proposed changes, which we'll come to shortly to the Fair Work Act. But the sting in the tail for WorkPac was not simply that this gentleman was considered a permanent employee and so therefore entitled to personal leave and annual leave that he didn't otherwise receive, but they weren't able to set off the amounts he was paid as a casual loading against what he would otherwise be entitled to. So when you run the maths and you say he might be entitled to $25,000 in leave entitlements on termination, they could not offset the percentage of the casual loading that he might have been paid, say if it was $18,000 against that $25,000 amount. So they have to pay an additional amount as well. So no wonder why it seemed like it was going to cost them a whole lot more money. What in effect happened was that Mr. Rosado was double dipping. Now, what the lessons for all of us, the lessons for our clients have been, it's time to review those casual employment contracts. It's not a good idea to have no casual employment contract. In fact, it seemed to be a very problematic idea. It's not helpful to have a system of employment that is systematic or kind of clear and ongoing. That's really unhelpful because what it does is it actually identifies that maybe this person is not irregular. maybe this person actually is a casual employee and we need to deal with that appropriately. The other thing to bear in mind is it's important to have appropriate set-off provisions, and the case itself is about 300 pages long. It's well worth a read if you need a cure for insomnia, but I certainly found it gave some clarity around what a set-off should look like. But ultimately what it came down to is it takes pretty careful construction to get it right. So all this means is it's probably time to review your staff, review how you're rostering them, scheduling them, review what the employment contractual documentation look like, and make sure that your set-off clauses are actually up to scratch. Make sure that your casual provisions around the loadings are actually up to scratch. If you don't do that, you might find yourself in the same position as WorkPac has found itself in. Now, I said we were thinking about, and the underlying idea of the way the law is changing is about the fact that people don't want to have unpaid entitlements. They don't want to be underpaid. And no more has this been clear than the annualised salary regime that was introduced effective from 1 March last year. In a nutshell, for some employees who are full-time and covered by certain awards, if they're paid an annualised salary, there needs to be a separate agreement. And the reason why is that even traditionally, it's been really beneficial to employees to have an annual salary, so that way you can avoid having to track hours. You can avoid having to worry about, overtime allowances and dealing with all that. Have an important set-off clause in, and the employee is benefits from that by having a predictable income that they can see over a year period, for the purpose of, say, purchasing a house, getting finance, etc., for a mortgage. What the Fair Work Commission, in its infinite wisdom, decided was that there was still too much rorting of this particular regime going on. And so they acted to change the regime in a number of awards where they took the view that either there were significant underpayments going on, people were using annualised salaries to avoid having to pay penalty rates and overtime, or that there's just really predictable, but there should be some recognition given to the extra hours that people perform. But it's not just simply a question really of whether someone's covered by an industrial instrument or not. The awards themselves talk about the steps you need to take in order to make sure it's really clear to all employees who are on an annualised salary whether they should agree to it or not. And the annualised salary really should set out what the individual can expect to be paid over a 52-week period, how they're going to be paid, and then how you're going to account for any overtime or penalty rates. And just to make things all the more complex, there's actually 3 different settings in a sense that are used, because there's 3 different types of categories that the Fair Work Commission considered were really needed to be handled differently. Those who have fairly set hours, those who have a mixture of set hours or maybe tend to work weekends, and then those people who have a significant amount of variable hours. So when you think about that first category, those who already would have an annualised salary provision in the awards themselves, you don't need to require an agreement. It just happens. And the way you do that, of course, is making sure you communicate to the employee that they're on an annualised salary and what that looks like. If you're trying to work out who this might affect, think of your receptionist at the front desk. Think of anyone who's covered by, say, the Clerks Award. Hours are pretty standard. But there might be occasional overtime or extra hours being performed. So you need to acknowledge that in your letter. The second category, it really is thinking about employees with highly variable hours or hours that would otherwise be covered by penalty rates. Good examples for you to think about: anyone in allied health. Often they work weekends, Saturday shifts. They are people who would normally pick up some type of penalty rate or entitlement. They're people that need to be covered by this second category of annualised style salary arrangements. And the third category are those who the annualised salary provision talked about a percentage in the award, and they're your retail, they're your hospitality, people who are, I would say, probably some of the most affected by being underpaid in business, more generally speaking. 3 different types of modern awards. model clauses to deal with annualised salaries, all requiring some documentation. They came into effect last year, but the word on the street is now from 1 March this year, the Ombudsman will actually start seeking to consider and engage a whole lot more with whether employers have met their obligations. So it's all the more important to ensure, like we talked about earlier, the correct award coverage and that you have the correct paperwork in place. But it's not just about documenting the agreement, it's also bear in mind that there are other requirements, and those other requirements include a reconciliation at the end of each year. You can see there are requirements to reduce things in writing, keeping records of unpaid breaks that employees take and start and finish times. It's like the old swipe card system for work, touching in, touching off, swiping in, swiping out. These are things now that really need to be documented in order to ensure compliance. So it might mean that you do go back to a swipe card system. It might also mean that you just simply elect to pay people on hourly rates again. This, of course, is the other side of this particular coin, that you'll actually slip people to work at hourly rates rather than pay them an annualised salary. So you need to be thinking about what's the interaction between the awards covering your employees and any annualised salary arrangements. Make sure that those arrangements are consistent, and then make sure payroll can implement those systems effectively and clearly, particularly around the record keeping for time requirements. So thus far, we've really talked about changes to regulatory regime, state level, and then casuals, annualised salaries, really talking about all of them in one sense or another, either dealing with non-payment of wages, underpayment of wages, and award classifications. But now I want to look forward, look ahead. The Fair Work Act changes as they're possibly going to be, which have been introduced in the Senate this morning. The bill is introduced, pretty much hasn't changed all that much. There'll be one change which we'll come to in a moment. But the big ticket items that we all need to be aware of are the creation of a definition of casual employee, oft muted, been left to say the common law, but now it's going to have its own definition. There'll be inserted a casual conversion mechanism. So not only will employees need to be grappling with the definition of casual employee and whether they meet that, but whether in fact they're going to be in a position to offer casual conversion after 12 months for an individual to convert to permanent. If you've been dealing with this in awards, and it's very similar, they're not identical. The other important part is there will be opportunities to offset identifiable casual loadings for if someone goes to court saying, hey, I was casual, but I should have been a permanent employee. The court now has power to will, if these pass the Senate, have the power to say, well, that may be the case, but you can't double dip. Really important changes to, in a sense, give certainty and confidence to business and employees, but also some transparency to employees. But they're not the only changes. There are also some modern award changes that deal with the JobKeeper flexibilities. Some of these relate to working from home. We've all had to go through that. Now I'm in the office today, but in the midst of a lockdown for all the Victorians online, a lot of us were working from home. And what that meant was that some of those flexibilities, some of those good flexibilities will actually remain. Some of those flexibilities will actually stay and they'll be implemented in awards. Now, the Fair Work Commission's jumping up and down. They feel like their job's been taken, but they may well come into effect and give greater flexibility also for part-time employees to work additional hours at ordinary rates of pay. Having worked on a matter recently, just in relation to this specific question, this will be really useful in terms of ensuring that you can offer additional work to your employees without them having to be paid overtime or penalty rates just for the privilege. There'll also be some changes to enterprise bargaining. The boot test won't be changed after some negative press and reviews by some unions and academia, there'll hopefully be a continued simplification of the Fair Work process to get these enterprise agreements through. And I should say that's an important thing, because the government, I think, is really hoping to push people onto enterprise agreements as a way of just managing the workforce better and getting them off awards, which we all know are somewhat complicated and to some extent a little archaic. But there'll also be more compliance and enforcement powers given to the Ombudsman. And to some extent, if we've not been paying much attention to these changes, these are some significant ones, because really the Commonwealth Government is looking to cover the field with the criminalisation of wage underpayments, or wage theft, as some people would call them, increased penalties for serious contraventions and sham contracting. I'll touch on that briefly, in that independent contracting itself, just like casual employees, is somewhat of a protected animal, but also it's coming under more and more focus and examination as to whether independent contractor arrangements actually exist. Having gone through a litigation around underpayments late last year, it certainly is clear, and there's a growing weight of evidence from the courts, that they're not really entertaining contracting arrangements in the way they did. And there's a lot more focus on exactly the type of relationship as between parties in real terms, they would say objective terms, not necessarily the commercial terms that the two entities may have had when they first went into the contractual arrangement together. So just as it's time to review casual employment agreements, it's actually time to review your independent contracting arrangements. There'll also be increased powers to the Fair Work Commission to deal with underpayment of wages claims. So if someone can claim underpayment of wages at the moment, if they have a claim of less than $20,000, it's dealt with in the small claims process of the Federal Circuit Court. That's expected to lift to $50,000 and be mediated by Fair Work Commission members. So hopefully that will keep them moving forward. But also it means that audits, which I know that my friends at Sayward Dawson have been working on, wage audits is something that you really probably want to get ahead of the game on if you're worried that there are underpayments. That said, I know some of you might think that it's a real concern, and just because people like the ABC or Wesfarmers got it wrong doesn't mean that you necessarily have it wrong. But now is certainly the time to be asking questions, particularly where you're dealing with employees that have a number of different penalties, loadings, and rates along those lines, and allowances. Better to be asking those questions now and rectifying issues before changes to this legislation come in. Two more topics I really want to deal with actually kind of now swing the conversation from what is ostensibly underpayments of wages, award analysis, making sure you're complying with those wage type requirements, and moving to what really are, to some extent, occupational health and safety issues. The first one is around the no jab, what I've taken to saying no job issue, and that is around the COVID vaccines. Now, we've all seen in recent days that from the Prime Minister on down, people are getting the jab. And so the question is, what do you need to do as employers in the situation where you may want to require an employee to have a vaccine? Well, the first thing you need to start asking yourself is, do you actually need them to have the vaccine to perform their role? And what we'll see shortly there are some organisations where it's accepted that vaccines and taking vaccines are as a reasonable request, but you need to, and there are some where it's not, but you need to be able to identify, I think with great skill and care, whether you think it's a necessary requirement or not, and then be able to justify that requirement. Is it an inherent requirement of the role to have a vaccine? Well, that might actually come down to both the role that's being performed, but to whom that person is performing the role. Is it internally to me and a colleague of mine, or is it actually to someone who's vulnerable? That's something to be thinking about. Then you need to be thinking about whether it's actually reasonably practicable, to implement that as a measure as opposed to an alternative measure. Does someone need to have a vaccine? If they say no, what's an alternative? Is it that they get dressed up in full PPE and are able to attend to providing, say, healthcare or caring for someone else in that particular manner? how do you deal with people that are vulnerable? And the last question, of course, is asking, well, if you require people to take vaccines and if you have a policy in place, which you should have a legally enforceable policy in place, would any direction to take the vaccine be lawful and reasonable? And we're going to look at that now because it's the next two cases, I think we'll really just touch on that really briefly. The first one is Arnold and Good Start Early Learning. Most of us will be familiar with it. Good Start Early Learning insofar as they provide childcare services. They had a mandatory flu vac policy for all workers except those with a valid medical exemption. A group leader refused to take the vaccine. They were terminated. Employee brought an unfair dismissal claim. And in some comments made by the Fair Work Commissioner at the preliminary point, they're accepting that you can have a policy, and it was reasonably lawful and reasonable in their mind that there was a policy because the centre involved the provision of care of children, care of vulnerable people. So on that point, is it necessary? Well, actually, it seems to be lawful and reasonable to have a policy in requiring COVID vaccinations, or sorry, flu vaccinations in this case, unless there was a medical reason to do so, which means you need to be thinking about that type of conversation. But for instance, if we look at the more recent decision of Glover and Ozcare, we'll see that sometimes it can go wrong, very, very wrong. And that's particularly when you miss the lawful part of the direction. In this particular case, an employee was placed on indefinite unpaid leave because they refused to take a mandatory flu vaccine. Prior to this point, it had not been mandatory, but then it was changed when COVID came in. And the reason it was given each year by this employee was that she suffered from anaphylaxis, and that happened when she was 5 years old. She's now 65. But the employer had argued that the vaccination had now become an inherent requirement of the role in order for her to administer care and assistance to vulnerable people in the community. What it didn't, of course, tell you was that whilst this was an issue at the time, the employer made a whole number of mistakes. And one of those mistakes was the fact that they cut off her email connection and stopped taking her calls, which seemed to suggest she was terminated. Another mistake that they made, which of course only comes out in the light of day, was that they were relying on a public health direction that related to aged care and that didn't relate to in-home care, and that was somewhat persuasive to the Fair Work Commissioner at the time. I suspect that maybe if there'd been a conversation by Ozcare with their lawyers prior to or at the point when they were thinking about going down this route with this employee, they may have avoided some of this. I personally would have considered a duty of care aspect and whether there was no reasonable alternative for her to perform her work in another way. And if not, maybe you might have sent her off to get a medical assessment to see if she still had anaphylaxis issues. So there were probably a number of ways this could have been dealt with. So maybe this was a bit ham-fisted. But what these two cases really do tell us is the need to develop a policy for dealing with mandatory vaccinations, whether it's COVID or something else. Having a procedure to be able to respond to employees when they raise objections, knowing how to consult in relation to reasons for mandating COVID-19 vaccinations, and engaging with relevant employees to understand their reasons for declining. Because you also don't want to be in a position where you sack someone for a medical reason and then you face a discrimination claim under the Disability Discrimination Act. It's always good not to be in those situations. Finally, one area that probably won't surprise any of us who's online today is just the increased number of people who are dealing with mental health claims. Now, I'm raising this only now in brief because effective late last week, there were changes to workers' compensation claims around people who make a claim, a mental health claim arising out of their work. Principally from 1 July this year, any employee who makes a work cover related mental health claim will receive automatic reimbursements for the costs of counselling. And any other, that doesn't necessarily mean they'll get the weekly payments. There'll still be an investigation period. But at the moment, the current process is there's a delay of payments until a claim is established. That will be no longer. It's a little bit more in in line with New South Wales. What that means, however, is that, and obviously the policy behind it is to encourage employees to seek counselling, but ultimately, regrettably, that's going to come at the cost to employers on their work cover premiums. Any claims made naturally increase premiums. So we'd be certainly encouraging you all to think about in your organisations how you can best support people's mental health in relation to an appropriate policy, and also how you engage with them while they're at work. That may well mean that you're dealing with it from the perspective of having a policy, doing training, anything along those lines. But this is an area that's developing and continuing to develop, and in a no-fault system such as this, you really want to be able to deal with these types of claims head-on, particularly if it comes to the point of claim investigation. You want to be able to show that you've taken all reasonable steps in the circumstances. Now that's it from me. I can see there are a few questions which I'm going to turn to, and if you've got some questions, please don't hesitate to write them down. I'm more than happy to answer them as I go, and I will do my best to try and get around to all of them. I think I've answered Philip's question, but to the extent that the Victorian Long Service Leave Portability Scheme is an issue, it is covered off, as I said, in the ACT and in Queensland. Other states may or may not introduce it, but it's fair to say, Philip, that there's a little bit of political affiliation and colours that really influence whether this legislation is introduced. The states that have it are all currently governed by centre-left parties, and so that does change whether it'll be introduced. Same with labour hire licensing, and to the extent that it's informed. Vanessa's mentioned that they have a mixture of employees under the SHADs and our EBA. EBA workers may work across residential and aged community care. Would we have to register EBA employees? In relation to the portability scheme, that's a nice, easy one. You're still required to register people, even if they're covered by an EBA. You just need to make sure you know which employees you're dealing with, and that might be a question for another time. Vanessa. Janine is asking for a comment on HR around staff experiencing family violence. Oh, I guess there's much to be said. I think the one comment I would make is it's a pretty fraught area. Part of it is removing the stigma so that people don't feel like they are in any way unable to raise it as an issue. I would also, though, encourage you to think about whether you've done training with managers, and I don't think there's much that's been done, training with managers in relation to the extent that it's applicable, how they manage people or how they identify issues, because sometimes they do present themselves from time to time. The issues do present, and it's often unstated about what's going on. So certainly something that I think is worthwhile and necessary is actually employers training their managers more proactively in identifying those types of issues. I think it will also become more and more apparent as domestic violence leave, if it moves from unpaid to paid, that will become an issue. It's really important to note that domestic and family violence leave is now an entitlement for all employees, unpaid leave. So there should be a policy around how you deal with that in any event. And hopefully that gives you some comments. I'm happy to take further comments, Janine, as the case may be. John's asked about annual salaries and whether it's an annual salary to be paid over 365 days in a normal year and 366 in a leap year. Or do you average on the basis of 365.25? Thank goodness I'm somewhat familiar with my maths. You take it on a year, as far as I'm aware, a year by year basis given, but I would expect that it would be more treated on the 365 as that's a standard year. Now, Mel Lewis asks, if you offer a regular casual staff member to go permanent part-time, but they do not want to, what do you do as an employer to protect yourself? I think this is an excellent question. And like every good lawyer, my response is, have you got something in writing and have you documented it? They're really key. Having dealt with a very similar matter myself, where the employer kept on offering to convert from casual to permanent, and they kept on saying no. They made sure they had it all in writing. So email trains are really important. At this point, there's no suggestion that if someone rejects it, that the employer still needs to convert them. It still has to be by agreement to change someone's employment position. The other thing, though, you really do want to think about is if they become a cheesed off individual, how are you going to best deal with that? On the one hand, I think it's regularly asking a staff member. So if they say no the first time, after 12 months, you revisit it maybe 6 months again, or 12 months down the track. You keep revisiting the question, because it's essential. You still don't want to be caught out by just them saying no the first time, when in fact you might find out a little bit later that they don't. You should also watch the space, Mel, for the change in the definition around what a casual employee is, because I'd encourage you, we're all going to have to make a shift. And the shift will seem to be that there will be some allowance for systematic work. So you want to make sure that your casual contracts reflect the changes in the award, which will mean you'll want to be talking to someone like me to make sure you get it right. And then you want to make sure that your actual practices in place actually reflect that as well. Freya there has asked a question about mental health, and is it necessary to show that current issues are possibly related to any pre-existing mental health issues? There is an exception in relation to the workers' compensation regime if you can show that there's a pre-existing injury. I think mental health is a little bit trickier because it's a lot harder to put your finger on it, so to speak, and it's a lot harder to kind of show when it's been exacerbated or not. I think, though, you should, as it appears that you do, should have some type of pre-employment declaration where the employer actually discloses any injuries they might have, or any pre-existing conditions. That doesn't mean you can't employ them. In fact, I'd recommend you not doing that, because you're looking at a discrimination claim straight up and down. But one way of dealing with that is actually by knowing before you take someone on board that in fact they do have the actual presenting issue. So think about getting a pre-employment health declaration in place for future for future employee employments. That's a good place to start. So I've been asked whether all employees under SHADS, irrespective of the type of role, be registered under the Portable Long Service Leave Scheme. Certainly they have to be performing or assisting with the performance of community services work. You do have to make that, you do have to answer that question. You do have to track through the way the legislative formula is created. I query, though, whether admin and finance are actually required. And I'd query, depending on your operations, whether you need to actually be a part of the conversation at all, because not all long service, not all organisations who may seem to be in the community service sector actually would be covered by the regime. Thanks, Nellie. And I think, Shelley, your question is very similar to Nellie's question. So I'll if there's something else you want to ask, please do. Geraldine, if none of your employees are caught under any of the modern awards mentioned, does that mean that we are not caught under the Portable Long Service Leave Scheme? That would appear to be the case. Georgette, in answer to your questions, yes, you're welcome to contact me directly in that regard. Philip finally asks, what are the key components of a mental health policy? Obviously, the key components of any policy are the company's position in relation to the particular issue. If it's just a statement about how the company will treat or deal with particular issues as they arise, and also any any legislative requirements, how they see that functioning. So for instance, you might want to talk about occupational health and safety, duty of care, etc. The best thing you can do though, dare I say it, Philip, is make sure you run it past a lawyer to make sure it actually ticks the boxes and you're not actually opening yourself up unnecessarily to any claims, that you're actually is sufficiently giving your organisation coverage, but also it's not tying you as the employer up in too many loopholes that you have to follow, and so avoiding mandatory language is really helpful. These slides will be circulated afterwards, and in that there'll be my contact details, so please don't hesitate to reach out to me separately if I didn't answer the questions or we didn't get around to it. Thanks, Murray.
Thank you, Adam. Well, we've made the timing's been excellent. We haven't gone over time. We're actually a little bit under time. So
that's a first for a lawyer, isn't it? Being under time.
You've done well, Adam. So any further questions, as Adam has said, you can make contact with him. I think today's presentation has demonstrated just how important it is to receive the correct advice. And so reach out to Adam. His contact details are on the slides. You'll be getting a copy of the slides and a copy of this recording as well. But employment law issues are just too important not to have right. You don't want to get it wrong. When you're talking about the WorkPac case, Adam, I think that was a great example of where the intention in the arrangement was to be one thing, but the documentation and processes failed, and then there was risk and consequences for the employer. You don't want to be in that situation, and so it's been an important reminder for you to make sure that all employment aspects associated with your organisation are up to date, and get professional advice. We try to educate our clients to not just assume that everything is okay. You should actually assume that things are not okay and then get advice to make sure that things are in order. That's a better way to view things. You don't want to assume that things are okay and then find out because of a claim or an issue that things were different to what you expected. So make sure you get advice. In terms of how we can assist you, that's Say with Dawson. We obviously can't give employment law advice. You need to speak to Adam, someone like Adam, in relation to that. We can help you with other remuneration type matters, fringe benefits, tax, salary packaging, looking at things from a taxation perspective generally. So if you need assistance in any of those areas, please feel free to reach out to myself or your usual contact at Say with Dawson. Okay, that's not a question, that's just a comment. Carol, thank you. You found that very informative. That's great, thank you. Thank you everybody for your attendance today. I think one positive thing from COVID-19 is that it's in causing us to do a presentation like this online, we've had a much greater participation. We've had a huge number of people attending today and a greater number of people registering. Some of those people obviously just wanted to get the recording and the slides. And so we've actually been able to achieve a greater audience than if we had this presentation on our premises. So that's been really, really positive. So thank you to everybody for your attendance. Please remember to complete the survey when you exit at the end of this presentation. Thank you once again, Adam, for your time today and all your expertise and the effort you've put in to make this presentation excellent and very valuable. I've really enjoyed it, and just looking at some of the comments here, everybody, based on those comments, everybody else has enjoyed this as well. So thank you, Adam.
Thank you, Murray, and thank you everyone for your time. I hope it means that there are fewer problems, and dare I say it, don't have to speak to many people after this because everything is travelling smoothly.
Very good. Okay, well, until our next presentation, or the next time you turn up at the Sabre Dawson office. Take care and stay safe. Goodbye.